Welcome back, everyone. Now today we're going to finish out this chapter and we're going to take a look at some other realms of equal employment opportunity. We're going to take a look at diversity, and we're going to take a look at diversity training and some of the efforts out there that you can incorporate into your organization to become more socially aware and diversity sensitive. So today we're going to take a look at the final portions of this, and then we'll move on from there. Well, today, everyone, we're going to be finishing out Chapter 3 as we finish up the law and particularly equal employment opportunities. Now, disability is another area that we need to pay close consideration to. The first form of litigation, or the first law really that was passed that covered disability, is the Rehabilitation Act. And this provided for equal employment for disabled workers and applicants by federal contractors. Now, this applies mainly to, and strictly to be honest with you, federal contractors. It was enacted in 1973, and it's still in force. But these are the first attempts to consider people with disabilities as being a protected class. Now, we have evolved this initial act into the Americans with Disabilities Act, ADA, and it is enforced by the EEOC, and it applies to private employers, employment agencies, and labor unions with 15 or more employees. Now, the amended acts broadens the definition of individuals with disabilities to impairment without regard for medication or prosthetics. So what the amended ADA did was just expand the scope of people, whether you're taking medicine or not, whether you are wearing a prosthesis or not. If you are disabled, and there are many categories of disability out there, you are protected under this act. Now, let me go ahead and just scroll through all of this so that we can take a look at it. Persons with a disability. If one of these three things happens, then you have a disability, has a physical or mental challenge that greatly reduces the ability to perform important life functions, possesses a record of such challenge, is thought to have such a challenge. So any one or all three of those can pose a legitimate claim for a disability. It's considered a disability even if corrective measures are taken. So let's say you have a disability you may have an artificial arm. You may be, for all outward appearances, it may seem apparent that you're not disabled, but you may have that prosthetic that corrects that impairment, but you would still be considered disabled. And it also includes internal bodily functions as well. Mental disabilities includes depression and anxiety disorder. It includes temporary injuries such as brain trauma. Employees who develop disabilities shift to jobs where their disabilities do not affect them much. They're not saying you have to keep them where you had them, but if you can move them around to areas where they're not going to be hampered by their disability, you need to do so. Now, here are some of the requirements that ADA and the law requires. You have fundamental job duties. Now, these are the things that are necessary for you to do your job. Reasonable accommodation. It's a modification to a job or work environment that gives a qualified individual an equal employment opportunity to perform. In other words, if you can accommodate that disability, you're expected to do so. Now, how do you determine if a job function is essential? Well, a job function may be considered essential for any of several reasons, including but not limited to what we see right here. The function may be essential because of the reason the position exists is to perform that function. So we have one there. The function may be essential because there is a limited number of employees available who can perform that function. So there's another one. The function may be highly specialized so that the job incumbent is hired for that expertise or ability to perform that particular function. Now, evidence of whether a particular function is essential includes, but is not limited to, the following: the employer's judgment as to which functions are essential, and that's pretty much a subjective professional opinion. Written job descriptions prepared before advertising or interviewing applicants for the job. Now, this is important. Job descriptions. Now, we're going to talk about that here later on, but a job description is more than just telling the person this is what the job is all about. When it comes to pay, when it comes to performance, when it comes to retaining or dismissing a person, oftentimes the job description is what is used to substantiate your management decision. If the job description is not accurate, or if the person is not in keeping with the job description because the job description is no longer accurate or whatever, then you can get in trouble. Also, the amount of time spent on the job performing the function. How much of your time is consumed by that particular function? The consequences of not requiring the incumbent to perform the function is another one. And then the terms of a collective bargaining agreement. And what does that mean? That means the unions. What have the unions negotiated when it comes to these job functions and so forth? And the work experience of past incumbents in the job. What have they done? How have they performed? And then the current work experience of incumbents in similar jobs. So you would probably want to do a little bit of benchmarking there to determine if a job function is essential and the evidence that you need to provide to make sure that the job is essential. Now, undue hardship. It's the significant difficulty or expense imposed on an employer when making an accommodation for individuals with disabilities. Now, normally, and it's just a rule of thumb, according to the courts, on average will cost the employer about $500. It may be building a ramp. It may be doing other things, and we're going to take a look here in just a few minutes at some of the examples of reasonable accommodation. But when it comes to reasonable accommodation, if you can make arrangements that's not going to impose a harsh consequence on your company, you have to make it. And the dollar amount that they usually assign to this is around $500. Now, the general guidelines for undue hardship are provided by the ADA. So if you want to know what a hardship is or what an undue hardship is, it's going to cost you more to be able to put that person on so that you're going to risk your profitability and so forth, then you're not required to hire that person. But the ADA has those guidelines. It is determined on a case-by-case basis. There's no cookie-cutter approach to this. They take a look at the disability. They take a look at the situation. They take a look at the essential job functions. And if you can prove that and that the person would cause an undue hardship if we put them in that position, then you're okay. But if not, you're going to be expected to hire that person if they have the KSAOs and are qualified in all other respects. Now, here's some of the examples of job accommodation or reasonable accommodation. You can modify work schedules. You can use special equipment. You can restructure the job. You can give them additional training time. You can provide employer-provided assistance, and then job reassignment and so forth. You want to make every opportunity available to that person to keep them, because whether they have a disability or not, these are people who have knowledge that can help your organization thrive and grow. So just to deny a person that ability or opportunity to come and contribute, you may be selling yourself short. But reasonable accommodation, again, from a dollar standpoint, you're looking at about $500. That's been the average. And these are other areas that are outside the money realm that you can do to take a person and keep them. Now, ADA guidelines to facilitate job accommodation. You need to identify the essential functions of that job. You need to determine which accommodations are reasonable so the individual can perform those core job duties. Architectural barriers should not block access. So again, if you have to build a ramp, you're expected to do that. Now, most buildings today, if they are working with a certain amount of people, 50 or more people. They're going to have handicap parking. They're going to have a ramp for accessibility. Most organizations will have an elevator so that no one has to worry about stairs and so forth. The working space itself, many today are in cubicles. They're open so that you have easy access and mobility throughout the floors. So most buildings today are fairly accommodating when it comes to people with disabilities. Work tasks must be assigned or modified to allow performance. Work hours and breaks may be adjusted. And then you have ADA restrictions and medical information. Now, these restrictions prohibit rejecting individuals because of a disability. If they don't have the KSAOs, that's one thing. But if they have everything going for them and their disability was what disqualified them, then you've broken the law. You can't do that. Asking job applicants any question about current or past medical history until a conditional job offer is made. Everything up until the point of making an offer is an interview, and you cannot do anything to make it seem like you are trying to disqualify a person overtly because of their protected class. Using pre-employment medical exams, except for drug testing, until a conditional offer is made. I was interviewing one time for the railroad company. They had an executive training program, and I was looking to go there. And then when it got to the point of drug testing, they took a lock of my hair, which was genetic testing. So that's really, from a legal standpoint, DNA testing, genetic testing, and all that chemical testing, that invasive can be illegal unless it's tied to a BFOQ, which is the bona fide occupational qualification. Now, we're going to talk about DNA testing here in a little bit, but they were well within their rights to have a more invasive and extensive drug test just because of the nature of that business. I would want that for an airline pilot. If I'm flying, I don't want that person on drugs. I want to make sure that that person is clean and has a clean history and so forth. Or the same thing with a police officer or fireman or something like that, or a surgeon. Medical information has to be stored separately and securely. You can't just put that in the personnel files. Anybody can get access to that. So you have to store medical information in a separate place in a more secure containment area. Now, Figure 3.8 talks about some of the most frequent ADA charges filed in 2013, and you see here how extensive it is, from diabetes to orthopedic impairments on the back and other areas. So you can tell by just this graph alone how much disability has an impact on organizations today. Now, genetic bias, let me go ahead and scroll through this. Employers use genetic screening tests to make workers aware of genetic problems. And they terminate employees who may make extensive use of health insurance benefit. So if you are excessively taking health insurance or having to use health insurance and so forth, you may have an issue with that. But there is the Genetic Information Non-Discrimination Act, which limits the use of genetic information by health insurance plans and prohibits employment discrimination on the basis of genetic information. Now, when we first started getting into DNA, one of the concerns, especially among African Americans, was being singled out for the disease called sickle cell anemia. And they were afraid, the African American community was afraid, that if they were tested genetically and had that DNA coding, that they may not be hired. So it brought forth more speculation and worry, and today it's not used normally as a means of employment or interviewing unless in specific instances, as you see here. Now, the ADEA prohibits discrimination among all individuals age 40 or older. If you remember, back I think a week or so ago, I told you it used to be 70, now it's 40. So you cannot discriminate based on age against a person who is 40 years or older. And that's opened the floodgates for people to be able to stay in the workforce. And it does have its advantages as far as taking care of the people, but it also has a lot of disadvantages as you're limiting opportunities for younger people to be able to move up in the workforce. Then you have the OWBPA, which is Older Workers Benefit Protection Act, and it's an amendment to the Americans with Disabilities or Age Discrimination and Employment Act, and it protects employees who sign liability waivers for age discrimination in exchange for severance packages. So you're protecting their benefits and so forth for the buyout or sellout or whatever you want to call it. Now, when it comes to age discrimination, pretty much this is self-explanatory. You want to adopt an age-neutral selection and promotion practice, recruit older people to return to the workforce through part-time and other attractive scheduling options, and then phased retirements. Employees gradually reduce their workloads and pay levels. So with this, you're not having to suffer the traumatic consequences of an older workforce. You're just planning more effectively for an older workforce and eventually planning to phase them out. Now, religious preferences found in the United States. These are just some of the different religions out there. Now, religious preferences found in the United States. Religion is another area of diversity that you're going to have to address, and there are no shortages of problems with that. But what you see here is just a graph of the different mainstream religious makeups, and you see here by far Protestant, Christian, is 51.9, but you do have Catholicism, Mormonism, Islam, Jews, all of it that are a part of the fabric or the makeup of religious diversity. Now, religion and spirituality in the workplace. One of the challenges that you're going to have is the different religious practices that people want to bring into the workplace. If you have Christmas, the reason why many people don't have Christmas is because of the different religious backgrounds that you have in the workplace. You have a Christmas party, now you've offended the Muslims and the Wiccans and the Jews and all of the rest of them. So now we see winter holidays or winter celebrations or something like that, or end of the year Christmas party or something to where we can not call it for what it is, but be able to still have some type of celebration. What are you going to tell the Muslim who wants to pray 5 times to Allah every day and so forth? No, you're not going to work here because you're a Muslim. Well, now you've discriminated against them based on their religious preference and so forth. Now, if it's not a bona fide occupational qualification, you have to make accommodation to them. And what about the ones who want to let their religious convictions come into play when they are at the workplace? We celebrated the woman who refused to sign the marriage certificates for gay couples. I believe she was in Kentucky. I can't remember exactly where, but Christians, we stood up for that. But what about the Muslim who is in Walmart and refuses to touch bacon when a customer puts it up on the little conveyor belt to be checked out, or sausage and so forth? We would frown upon that. We would tell them, get with America. This is what we do here and so forth. So, what the government has to say about that is that if you're going to treat one person one way, you have to treat them all the same way. So religion and spirituality in the workplace. Part of the discrimination that goes on, as you see, can include hostile remarks or refusal to hire individuals with different beliefs. Religious expression, its expression by employees and or employers can be protected. managing religious diversity, changing an employee's job task or scheduling, and that's really for the Muslims, making an exception to dress and grooming rules. What would be your rule in the workplace as far as women wearing the hijab and the burqa, which are the head coverings, and the burqa is the full body covering? Would you feel comfortable? Would your employees feel comfortable working with someone like that? Making accommodations relating to paying union dues or agency fees, and accommodating prayer, proselytizing, and other forms of religious expression. You know, as Christians, we have an obligation to go and make disciples. How do we reconcile that in the workplace? Now, one of the things that you see here, expression by employees and our employers, can be protected. You do have the right to free speech. You do have the right to be able to stand by your convictions. You can't be forced to do anything that would be against your religious convictions, but those lines today are being blurred, especially when it comes to religion and Christianity in general. So we have to be careful, but we need to make sure that we are maintaining a equal and level playing field for all people, and to be able to still maintain really our Christian standard. Now, immigration and discrimination. Immigration is getting to be a hot button topic. It's not going away. In fact, it's becoming more prevalent in the workplace today, and it's going to continue to do that as we put people from other cultures into the workplace. Many are undocumented, which means they're illegal, and that's going to be an issue. Many cannot speak the language. Many are not assimilated into the culture. So pretty soon we may see the Congress passing laws where we have to hire illegal immigrants and so forth. But until then, what we have right now is the Immigration Reform and Control Act, which requires employers verify the employment eligibility status of all employees without any discrimination. And it requires an I-9, which is the employment eligibility verification, and you probably filled that out if you've worked anywhere. It requires your Social Security card, proof of American citizenship, and so forth, and verifies the employment eligibility of employees, and that's really what the I-9 does. It broadens visa requirements to accommodate high-skilled employees. Now, there are some programs that are in place where we look for people from other countries who have a highly developed skill that we need. We will bring them here on a temporary visa to be able to work and allow them to work, and as long as they're productive, we let them stay here and they continue to work. Now, just some of the documents needed for an I-9 compliance, and I'll let you guys take a look at that. You have A, B, and C lists here, which talk about the different forms of documents that are necessary. So we'll just let you take a look at that, and then we'll move on. The language issues. The EEOC issues guidelines stating that employers may require workers to speak only English at certain times or in certain situations, but the business necessity of the requirements must be justified. So that's kind of a hard blow when you're working next to people and you don't understand what they're saying. They're not speaking in English. You don't understand a word that they're talking about. You don't know if they're talking about you, talking about the organization, talking about whatever. But you cannot require a person to speak English unless it's required for that job. Now, USERRA is the Uniform Services Employment and Reemployment Act provision, and if you remember what I was talking about, I think last week, military people who are called to active service because of war or emergency, companies are required to make sure that they have a job when they come back. They don't lose their seniority. They start back just as it was when they left. Now, unfortunately, many organizations who don't want to have to deal with military people, they will find another position or do away with that position. And when the person comes back, they'll just tell them, hey, look, we did away with that job. And there's really nothing that people can do. But USERRA is the way that the government tries to protect those who go and serve and come back and make sure that they have a job waiting for them. Appearance and weight discrimination. Employers are allowed to set uniform dress codes and appearances as long as they are applied uniformly, and the job must be in sync or coincide with the height and weight requirements, or the height and weight requirements must coincide with the job function itself. So the military, for instance, you had to be a certain height and weight range. You couldn't go past that or exceed it or go under it, either way, without having to be screened out from the military. Same with, I guess, police department and military or fire department and some of those other types of organizations. They may have a height and weight requirement. And if you have a dress code, you have to be able to be in appearance with that. One of the reasons why many organizations don't have a casual Friday anymore is because of a landmark case, a Supreme Court case, where a company had a casual Friday as a reward for some type of fund drive they were trying to raise money for. But one woman came in with a halter top and Daisy Dukes, those short shorts. And the supervisor told her to go home and change, that it was inappropriate. But she said, no one told us what appropriate was. You just said casual Friday, and this is my casual dress. So she went home, but she filed a lawsuit. So even something like that, you can't throw parties without being aware that you may offend people. You can't have rewards like casual Friday without the possibility of offending people. So HR has its work cut out for it here when it's dealing with just this one element, diversity. And diversity training involves the legal, the cultural, sensitivity training. You have those three dimensions that you're going to have to be aware of and provide for the organization. And the mixed results of diversity training. You know, I've been in HR and dealt with HR for quite a while, but mainly there's really no training that's going to change the heart. You may have training that will keep you up to date on regulations and procedures and so forth, but when it comes to people's nature, that's something that training really can't do. In those cases, you have to reinforce good behavior and sanction bad behavior. And that means making example of people at times who just will not do right by others. But the results are mixed. When it comes to diversity training, some people swear by it. Others think it's just a way to just check off another sheet on the HR program to say that, yeah, we provided the training and we're up to par as far as the government standards are concerned. And these are just some of the common sense approaches. Focus on the behavior when you're training people and teach how to communicate with people of diverse backgrounds. And dealing with diversity is not about what people can and cannot say. It is about being respectful to others. So that's the intent of all of this, is just really, when you think about it, going back to the Bible. What does the Bible say? You know, by this they'll know that you're my disciples, if you have love one for another. So we want to follow that golden rule. Do unto others as you would have them do unto you. And we want to be good stewards of the resources that God has given us, and that includes human resources. And to be able to be good stewards of that, we have to treat them fairly, and we have to treat them equally. You know, the Apostle Paul made it very clear. In Christ, there's neither Jew nor Greek. But the one thing that Paul had to deal with when he was talking about this is discrimination. It occurred back then, and it's occurring still today. As the Bible says, there's nothing new under the sun. Unfortunately, as we interact with people in the workplace, whether it's ministry or whether it's in the professional realm, we're going to have these issues come up. I've had to deal with it, and you will have to deal with it, not just as professionals, but also as Christians. So we have a higher calling, as I had mentioned before, to act responsibly, to be good stewards not only of physical resources, but also with human resources. But this will give you enough to think about just how wide-ranging and the magnitude of the scope of diversity is, and to appreciate it and to become more knowledgeable about it so that you can be not only a better professional in the business world, but also be a better steward and minister of Jesus Christ. Next week we'll be in chapter 4, so have a good weekend, and I'll see you then.